Hi everybody, welcome back to Law Hero. My name is Jen. I make videos about the law, and at the moment specifically I'm making videos about the FE1 and March 2020 FE1 we just had because people like to hear these videos before they do the exam, just to give them kind of like a roundabout synopsis of what has come up and what they can expect. So it's kind of like a exam prep video. If you're not already subscribed, please subscribe, because I don't just do FE1 videos, I cover all areas of law, and you can check out all those different areas of law on my website, lawhero.eu, or daily I give like Instagram videos on at lawheroIRL on Instagram. So I just did EU. Today we're going to do company law. So one of my followers very kindly sent me on the company law paper, and if you have any March 2020 papers, please send them on, because the Law Society actually haven't put them up yet, and I waited a long time, but now it's gone on too long, so yeah, we're just gonna do our best. So the first question that was asked in the company law exam paper in March 2020 was a question around ultra-vires, okay? And if you go to my videos on why you fail company law and how to pass the company law and the FE1, I talk about ultra-vires a lot, and how that for limited companies it is a doctrine that no longer applies, but it does in fact still apply to the other companies mentioned. And this is what this quote is about, and you have to explain that. So I think if you go to my video on why you don't pass company law, I explain that much more detail there. Obviously it's in chapter 2, I believe, of my ebook on corporate capacity. Moving on to the next question on the March 2020 paper. I'm always drinking some form of tea, by the way. Insolvent director under section 819. Okay. Case line against direct control, he or she acted honestly and responsibly. Okay. So this is the test for restriction. So you need to go through that chapter. I have it under the chapter called Directors, chapter 5. It's like all that squash, la moselle. Chapter 5, Directors. Okay, question 3 was a problem question. So we've had 2 essay questions and now 1 problem question. Okay, we'll just get my first impression of it. I'll just actually read through this, because maybe the problem questions I can actually go through. Paul is the director of the company which operates a car sales business in South County Dublin. Paul is not a shareholder in the company. Okay, so he's not a shareholder. He's a director. Director's duties. But we're thinking he's not a shareholder, so we're thinking he might be held liable as a director. Which is owned by a family consortium headed by Simon. Okay, so Simon is a shareholder. Paul is a director. Although Paul has worked for the company for 10 years, he worked first as a car salesman, being promoted, blah, blah, blah. Being appointed with responsibility for sales. There are 3 other directors, all family members, making 4. So, okay. Simon is the majority shareholder and managing director of the company, and he approaches you for advice. Okay, so the shareholder is approaching you for advice about one of his directors. He has 4. It has come to his knowledge that Paul has been double jobbing. What do we think? Selling company information. He is in breach of his director's duties under section 220, conflict of interest. I'm guessing. Selling second-hand cars through a website fronted by his wife Jackie. Okay, this is just classic. Simon has heard that Jackie has been buying cars from Paul that were traded into the company at a discounted price before sending them on for a significant profit. Okay, he also has a duty not to profit. And Paul has been using the company's garage workshop to service the cars late at night, so he's using company property to benefit. On Sundays where the garage workshop was closed. He's used spare parts belonging to the company but has not reimbursed the company. Okay, so these are all director's duties here. Whether you believe that he's in breach of any duties, duh, he's in breach of a ton of duties, see chapter 5 of my ebook, and the remedies that are available to the company arising from any breach of these duties. Well, you definitely try and remove him as a director, wouldn't you? Because he's going nuts in there and he is tearing the place down. The money back as well. You'd imagine that he's under contract. You'd imagine that he's under some contract of employment. So that would be how you would do that. But yeah, he's breached his director's duties, and that can lead to a whole host of remedies for the company. Okay, so yeah, that's just a director's duties question. Okay, question 4. Damien is the sole shareholder. Okay, so before I even read this, if I think logically, right, just looking through the rest of the paper, there's a crystallization of floating charge. There is a section 31, which is the agreement between the shareholders as between themselves. Number 7 is it about company being struck off. That's not covered by my notes, but he hasn't ever asked that. Well, he has asked it, but like not in ages. And then an insolvency one. Okay, so if we guess that this one is maybe liquidation preferences, we'll just guess. Wrote a check, transfer 30,000. Yeah, so this is fraudulent preference. Sorry, I saw the word liquidation. This are payments and fraudulent preferences in liquidation. Let's see what chapter that is in my book. Debt is under chapter 9. But actually some of the fraudulent preference stuff is covered under chapter 5 because it's the director doing it. So yeah, just be wary of that kind of crosses over. But yeah, if we go back to chapter 9, okay? So we have unfair preference on or fraudulent dispositions under section 597 are covered there, and that's what so he's basically made 3 payments here, and they'll be void at the instance of the liquidator. Question 5, as I said, was an essay on the cause of crystallization of a floating charge. Charges in my notes are done under chapter 4, borrowing and charges. That's a really easy essay. Question 6, I really like question 6 actually. The answer to question 6 is under my chapter 8, shareholders, and it deals with section 31, which is the agreement between the shareholders as between themselves. The shareholders interact with each other, and that they are bound by the decisions they make, and that basically that they're representing, that they're acting in their capacity as a member, and not for anybody else. So it's basically like, whereas the constitution kind of looks after the day-to-day running of the company, section 31 kind of binds the members, their decision making. So we'll say the shareholder at a AGM or at a EGM, that once they've agreed, they can't go back on their decisions, basically, because otherwise the company will be in disarray the whole time. A good example is when a member takes a case against the company because the share price has come down. They can't do that because they are bound to each other, that the rights that apply to them. So we'll say if you're like a preference shareholder where you get extra dividends, or if you're an ordinary shareholder whereby the rights attaching to your shareholding need to be agreed upon, because otherwise if the share price goes up and down, you can argue, oh, like that's not what I signed up for. But the whole point of the section 31 is that you do agree by being a shareholder implicitly as to how things are, and that's the purpose of Section 31 as well. If you want more rights, like you'd normally have a shareholders agreement, but Section 31 is like a statutory enforcement of your rights as a shareholder, but also that it keeps everybody else in line. So I quite like that question. Question 7 is, as I said, when this company is struck off the register. Now, I don't cover post-incorporation or pre-incorporation or any of that kind of stuff in my notes, simply because it comes up so seldomly, and this problem question is testament to that. Like, this hasn't come up in years. I haven't seen it in the last few years, so I personally wouldn't have done that one. And then the last one, we see the word debenture, so I'm guessing it's receivership. Let's just go down. Yeah, so you're required to advise Harry on his duties as a receiver. So yeah, let's see. Chapter 3 is a receivership in my notes. So there you have it. It was, again, company law is just gorgeous. Like, I think it's so straightforward. It's very, very easy. There's never really any surprises. Yeah, he asked strike off the register company there, but like, you just wouldn't have done that question. Yeah, if anyone has any questions, please fire them at me, info@lawhero.eu. Lovely paper. Thanks to whoever sent it on to me. I'm sure I emailed you. I can't remember your name, but you are sound. And yeah, see you all in the next one.